Good afternoon and welcome to this week's McGill Alumni Webcast. My name is Derek Kassoff, Managing Director of Communications at McGill's Office of University Advancement. As the COVID-19 pandemic extends into its third month in North America, populations are growing restless. In some jurisdictions, as scientists and political leaders work to respond to quickly evolving situations, citizens are demanding that governments rescind or ease up on lockdown orders. Elsewhere, citizens are pushing their leaders to enact and enforce even stricter public health guidelines by cracking down on those who disobey physical distancing orders and demanding, for instance, legislation that would make it mandatory to wear a face mask in public. And lawsuits are starting to emerge from individuals and groups who feel that their rights are being violated or that they or their loved ones have been placed in danger by policy decisions. Perhaps it was only a matter of time before the COVID-19 pandemic became as much about the legal ramifications of government decisions as it is about the battles against the virus being waged on the scientific and medical fronts. It's Thursday, May 21st, and this is Power, People, and the Pandemic, the legal sides of COVID-19, this week's McGill Alumni Webcast. To help us unpack some of the legal implications of this public health emergency, I'm delighted to be joined today by three law professors, two from McGill's Faculty of Law, and one a doctoral graduate from the McGill Faculty of Law, who is now down the road at the Université de Sherbrooke. Not only do all three share a deep passion for public health law, but they recently teamed up to apply for funding for McGill's MI4 COVID-19 Emergency Research Fund in order to explore the various legal ramifications and lessons stemming from this pandemic. Their grant application was successful, and today they will share with us some of the issues they have begun to explore and answer some of the legal questions that have emerged as the COVID-19 outbreak continues to blaze a devastating path across the planet. So let me quickly introduce our three panelists today. First, we have Lara Khoury, who's an associate professor at McGill's Faculty of Law, the co-convener of the McGill Research Group on Health and Law, and an associate member of the Institute for Health and Social Policy of the Biomedical Ethics Unit. Welcome, Professor Khoury. We also have with us Professor Alana Klein, also an associate professor at McGill's Faculty of Law, and co-convenes with Professor Khoury the McGill Research Group on Health and Law. She's an associate member of the Institute for Health and Social Policy, as well as a former senior policy analyst with the Canadian HIV/AIDS Legal Network. Welcome, Professor Klein.
Sure.
And finally, we have with us Marie-Ève Couture-Menard, who's an associate professor at the Faculty of Law at the Université de Sherbrooke, a former DCL student at McGill under Professor Khoury, and a member of the Centre de Recherche sur la Régulation et le Droit de la Gouvernance. Welcome to all three of you, and thank you for joining us for this important discussion. So I think I'll direct my first question to Professor Khoury. I'm curious, when the initial round of McGill MI4 research funding was announced last month, it was no surprise to see researchers from the fields of science and medicine and epidemiology line up to submit proposals. I'm curious to know what convinced you and your colleagues from the Faculty of Law to move forward with your application.
Thanks, Derek, for this question. Well, along with many of my colleagues, I really view law as a constructive tool that can be a partner to other disciplines in promoting social advancement. And in the case of the current crisis, I really thought that law could help in designing strategies that better respect the diverse interests at stake and help in taking stronger decisions. So with this in mind, I really thought it was crucial that legal experts weigh in particularly on the decisions that each level of government, federal, provincial, municipal, are taking on a daily basis. So each of us, the three of us, are already experts in public health law, but we each look at public health law from a very different perspective. And I thought that joining our forces would actually create the ideal team, hopefully, to reflect on governmental decision-making from all the relevant angles. So Marie-Ève is a public law expert. She has a particular expertise on state governance. Alana's expertise on public health is through the lens of constitutional and criminal law, and I have been working on liability issues flowing from public health failures, but with a particular interest for infectious diseases. So the three of us together, I thought, would actually be able to cover quite an array of legal issues.
Great. Now I know you're just at the very beginning of sort of working through some of these issues as part of the research grant, but I may be curious, maybe I'll just go around and ask each of you if you could tell us sort of what is it about the COVID-19 pandemic that sets this public health crisis apart from any we have seen before in terms of the legal questions and legal parameters? And how are you going to be exploring that particular question or concern through the research grant over the coming weeks? Maybe I'll stick with you, Professor Khoury. You could maybe talk a little bit about from your perspective.
Yeah, well, there are a lot of questions, obviously, but from a liability perspective, I think this situation raises a lot of difficult questions that necessitate a lot of reflection on our part. And I'm just going to give you a few examples of what I think are the main questions. For example, how can we take good decisions based on uncertain and evolving science? Should the emergency of the situation and the lack of resources that we have to tackle it be taken into account when assessing the reasonableness of states' decisions? How can one identify who exactly is responsible for one's damage when the causal ramifications of every single measure adopted is very complex? And with a virus, as we know, which is transmitted very easily, and in that situation, it may be hard to identify when and where one has contracted the virus, except perhaps in some cases of outbreaks. Another question is, are there other and better ways than liability lawsuits to hold the state and other actors involved in managing the crisis accountable? And that leads me maybe to talk about what I think is a really fundamental question, which is whether suing in front of the courts the actors that are involved in managing the crisis for damages that we suffer the right societal strategy at this time. In other words, should our judiciary or judges assess the reasonableness of the decisions that are being taken by the state and by public health authorities, and is suing each other the right way to overcome and recover from the crisis? So this will be underlying a lot of the work that I and we will do together.
Right. I guess you can't sue Mother Nature, so people will be looking for other solutions.
I'll come back to I'll come back to that in a moment.
Yeah, there's a lot in there that I hope we'll get to unpack over the next little while that we have together. But let me turn it over to Professor Klein next. So you are our constitutional and criminal law expert on this panel. So what is it about this pandemic that is sort of unique from your perspective, and what are you looking to sort of tackle in terms of legal challenges here?
I mean, it's a truly unprecedented crisis. And three things in particular have struck me, the combination of which together is particularly unprecedented. One is how quickly it came upon us. Second, how broad the responses had to been, engaging so many different segments of society. And third, how, and this has already been mentioned by Professor Khoury, how governments and individuals have had to work with partial or evolving or often even contradictory information. So this has brought up particular issues around evaluating the appropriateness of government responses. It's led to issues around trust that have been really important. And that are, as I'll talk about it a little bit later, trust in government and trust in government's responses are really important to public health responses. And it's also led to these dynamics where people are afraid for themselves in different ways, perhaps, than other pandemics like HIV/AIDS, which are understood rightly or wrongly to affect particular segments that are often treated as kind of the other. And so in this context, it's been really interesting to take lessons from the HIV/AIDS context about the appropriate role of the criminal law, the limits of the criminal law, and of course, the difficult questions about rights limitation and what's a reasonable limitation on rights, because as I'll describe a little bit later in our discussion, no rights are absolute. And helping the public to be able to understand and buy in when it's necessary for public health reasons to some of the limitations, and yet at the same time to respond to limitations on rights that may not be in the public interest, or that maybe have been overlooked as policymakers move quickly and with partial information.
Mm-hmm. Great. And I do want to come back in a minute to the HIV/AIDS reference, because I know you've obviously spent some time earlier in your career working on that. But let's just turn over quickly to our third panelist, Professor Couture-Menard, former student of Professor Khoury's. So I know your work really sort of looks at the intersection between various governments and governmental powers and how the three levels of government will work together. So what is it that struck you most about this pandemic and the government response that feels so unique compared to other examples we have seen in the past?
Well, for one thing, the magnitude of the pandemic has, in some jurisdictions, such as Quebec, triggered the exercise of legal powers that governments have never applied before, or at least have never applied in such an extensive way, affecting this many people for such a long period of time. So in that sense, we are living through a real legal experience as Canadian citizens. And hence, questions regarding good state governance arise, such as is current public health legislation adequate in terms of how decision-making power is distributed in times of emergency? In other words, who exactly gets to decide, and what level of discretion is given to public health authorities to decide what is the appropriate response to the pandemic? And how is public accountability ensured, given that governments are making extremely delicate decisions in such a hurry? So these are all questions of governance we want to explore in our project.
Great, thank you. So let's turn back to the HIV/AIDS piece, if you don't mind, Professor Klein. As I mentioned in the introduction, you actually worked as a senior policy advisor on that file earlier in your career, and I guess for many of us, that was the single most significant global health emergency or epidemic that many of us have lived through up until this current one. Mm-hmm. So, can you tell us a bit about what some of the major legal issues you were involved with at the time? And do you see any parallels at all in terms of the legal dilemmas that society and governments and populations are facing today around COVID-19?
Yeah, so I'll start with talking a little bit about COVID-19, then I'll move to my work at the HIV/AIDS Legal Network and the kinds of things I personally was involved in. So around COVID-19, I just wanted to point out that sort of the primary measure, the most visible measure, sometimes the most talked about measure that we've seen in Canada and across the world is lockdown and restrictions of various kinds to limit spread. We've also seen other measures to support and facilitate social distancing and stay-at-home orders, like government relief packages that address some of the economic burdens associated with the shutdown. And these in Canada have been primarily targeted at the workforce, which is, of course, very important. But history has taught us that the most effective responses to transmissible disease come from human rights-based approaches that track and respond to vulnerability in quite detailed and specific ways. So as Marie-Ève reminded me as we prepared for this discussion, Professor Couture-Ménard, and as Lara, Professor Khoury reminded me, it reminded us in the beginning of this discussion, yes, sometimes we recognize limitations on civil liberties and human rights as ways of protecting the public, but actually protecting human rights is an important way of protecting public health. And that's something that I learned about in the context of HIV/AIDS in ways that are really important. So again, the human rights questions that arise are not just about the justifiability of given repressive measures. Of course, that's important, and I have a lot to say about that. But human rights are also about responding to vulnerability. And this is something that's become more and more evident as the epidemic evolves and as we learn more about it. So it didn't surprise me at all, for instance, and I don't think it surprised any public health expert, when we learned that the bulk of cases and the bulk of deaths were of people in vulnerable positions whose rights are not always respected. People in long-term care homes, people living in prisons, racialized communities. Things like shutdown don't, especially blunt kinds of shutdown orders, don't necessarily respond to these realities, but the law and human rights can respond to those realities. Mm-hmm. So with that lengthy introduction, I wanted to tell you about two things that I worked on. If you'll indulge me, when I was at the HIV/AIDS Legal Network. The first was the trajectory of the epidemic, and in particular, when I got to working at the HIV/AIDS Legal Network, HIV/AIDS was always a kind of mature, had become, a kind of a mature epidemic, in the sense that its trajectories were reasonably well understood. In the early days, of course, HIV primarily affected gay men, but by the time I was working on this, The two populations that were fast-growing populations among people living with HIV were women, particularly women whose rights were not protected, and people who use drugs. In the case of women, for instance, yes, we learned that there was some unique biological vulnerability just because of the way women's bodies are made and the way men's bodies are made, that rendered women more vulnerable to transmission. But the real reason behind the transmission was their lack of power to dictate the terms of their sex life. And so we worked on the human rights of women living with HIV. I focus particularly on women in sub-Saharan Africa, but this is true for women across the world. In the case of people who use drugs, it was unsafe consumption practices that were driving the epidemic, and those unsafe consumption practices were a consequence of different forms of stigma and criminal repression. And so a lot of the work that we did was about pushing for laws to change, pushing for changes in laws to address that kind of vulnerability. So bringing again back to COVID, as I said, we've seen some recognition that people need resources in order to be able to respond to the public health demands being placed upon us as a collectivity in the form of relief packages. But we've hardly even begun, in my view, to tailor these responses specifically to vulnerable groups who can't self-isolate in the same way as everyone else, and at the same time remain fed and clothed. Montreal North, for instance, has emerged as a COVID hotspot, and this can be traced directly to the fact that people simply don't have the resources to physically distance oftentimes, and of course that a disproportionate number of residents of those neighborhoods are working in long-term care homes and under quite precarious labor conditions. And so the point here is that labor rights, just as women's rights are necessary to expect women to be able to protect themselves in the context of HIV, labor rights are necessary for health protection where COVID particularly affects workers.
Mm-hmm. And I guess at the end of the day, a lot of it really comes down to this question of protecting people's basic human and civil rights and certain freedoms that we take for granted versus protecting populations and their health, right? Now, so I'm curious, in the case of AIDS and HIV, were people in fact found to be criminally responsible for knowingly spreading the HIV infection if, for instance, they weren't disclosing their condition to sexual partners?
Yeah, so that's another area that I worked on was criminalization of HIV non-disclosure. When I first got to the HIV/AIDS legal network, Canada had become one of the top leading countries in criminalizing HIV. And it was fascinating because this wasn't some deliberate HIV-related policy of government. Rather, it just came from some creative interpretation of existing criminal code provisions from prosecutors. And that eventually became the norm. So it wasn't really part of Canada's HIV response to criminalize, not deliberately, but it became a part of the country's response sort of by accident that way. And it's interesting because, well, it was an accident, but it wasn't a public health driven response. And of course, now we're hearing for more calls, sometimes for use of the criminal law, a little bit less now, interestingly, as people are resisting the lockdown measures, and I guess as people, as the dynamics of the epidemic change. But we still see them. People who, calls for criminal negligence, murder even. I saw in an Italian context, someone contemplating a murder charge for someone who was failing to social distance. A woman in Newfoundland reportedly spent a night in jail for failing to socially distance. And yet, what I learned was that when it comes to what I learned in the context of HIV/AIDS was that public health experts across the world have been unanimous that this is not at all helpful, and indeed, it's counterproductive from a public health perspective. Not only because it drives stigma, which interferes with safer sex practices, but also because it's discriminatory. And so public health experts had long adopted the position that actually the best way to get buy-in was to offer people realistic, serious, public health informed knowledge and the power to act on it, not to criminalize. And so I've been working on trying to understand the value of this lesson in the context of COVID, and how to respond to sort of the public's sense as, especially as we were in quite severe lockdown before there was a thought about reopening, and when people were especially afraid I think now people have managed their fear a little bit more, for better or for worse, maybe not necessarily always well. But criminalization can be kind of an easy way to respond to your fear or your anxiety, but it's not actually helpful from a public health perspective.
Right. So now when we go back to sort of the current COVID-19 pandemic, what I find so tricky, obviously scientifically and medically with this virus, and also I guess from a legal perspective, is the fact that any one of us might be asymptomatic or pre-symptomatic carriers of this virus. We might be the ones who are potentially infecting others and need to be protected from other people, which I guess is what really leads to this really intense debate about the balance between civil liberties and the protection of our health and, of course, the health of others. So normally I like to save the alumni questions for later in the webcast, but we did get one that came in a couple of days ago that I think really sums up a lot of what the debate is about. So I'm going to sort of put it out now to you to sort of respond. This one, it was an email that came in from Purino Torby. So he wrote, considering the constitutional right of a Canadian to move and take up residency in any province and to pursue the gaining of a livelihood in any province, how far can I as a Canadian go to legally challenge the current restrictions and refuse to let go of these rights in order for them not to become a precedent moving forward? In other words, can we refuse to comply with social distancing measures, i.e. to go visit a parent, a relative, or a friend, or to travel to our cottage, wherever it is in Canada?
Okay, so is there more?
Yeah, no, that's it.
Okay. One important thing to realize in general, this is a really big question, obviously, and I'll get to the point of what an individual can do in terms of refusing in just a moment. But I want to start by explaining, by sort of setting the table a little, by explaining that in general, civil liberties are not absolute. And I think it's important for people to realize that. You see some of these protests against even the most basic of public health responses in some parts of the world. And it's important to recognize that actually civil liberties aren't absolute. They can be limited by law for important objectives. And the legal principle is that limitations of people's civil liberties have to be necessary, and they have, or at least related to the objective that they're seeking to achieve, and proportionate. So the question about things like wearing a mask, avoiding the beach, staying away from your cottage, and so forth, the relevant question there is, and of course, these are more than just for your own individual health, right? These are to prevent community transmission. And so the objective that they'd be measured against is, are these related to protecting against community transmission? Are they proportionate? So those are the questions. And of course, that question has to be addressed with limited information. And that's something that Professor Couture-Ménard pointed out at the beginning as we entered this discussion, but that, and Professor Khoury as well, actually, and I think that's a theme in all of our work, is that we're, governments are working with limited, often contradictory information against a very serious public health risk. And so it may be, as information changes, that, for instance, the CDC today or yesterday said, well, it turns out that transmission doesn't happen easily over surfaces, right? But that's not something that wasn't the same wisdom that we had 3 weeks ago, right? Now we understand it's mainly through droplets, and that's why we've seen an increase in reliance on masks. But this isn't something we knew. So the question of whether it's proportionate needs to take into account the fact that we're operating in this situation of factual uncertainty. Yeah.
Right. So let me just turn it back to you, Professor Khoury. You mentioned earlier, you referenced the fact that, at least here in Quebec and in other jurisdictions, essentially a public health emergency was declared. And that sort of set up this umbrella for governments to kind of do what they want in many ways. So I guess my question to you would be, does just the declaration of a public health emergency, such as this pandemic, justify the creation of all these laws that some would argue are limiting our civil liberties? And has the population, in your opinion, been too willing to accept these laws, which have fundamentally changed their lives in so many ways? You're on mute. You just no problem.
I promise not to do that. Okay, so I think the first part of the question is probably Professor Couture-Ménard can answer better than I can. I just want to say maybe a quick word about the the reference to being too willing to accept. I think our idea is that, and this is just the beginning of an answer. We hope that law can provide check and balances that will reinforce the public's trust, knowing that it participated in solidifying the decisions that impact us. And so in that sense, I think we do want to participate to people being able to take reflected decisions as to whether, they buy into the public health measures that are being taken. But for the first part of the question, I believe maybe Marie-Ève has a little bit more to say, or Alana, on the emergency aspect, declaration of emergency aspect question.
Sure, Professor Couture-Manat, is it fine just to put out this declaration and then governments do what they want with it?
No, so I think, okay, I understood that. Maybe the question was, does a public health emergency such as COVID-19 justify laws that limit our civil liberties? I think Professor Klein answered told you a lot of elements in her response, but I would say this really calls for a collective sense of health as a common good. So what's interesting is when I looked up at the legislative historic of the Public Health Act of Quebec, I noticed there were no debates around the declaration of public health emergency. It's like everyone was okay with the fact that when our collective health is threatened, we will give extreme powers to the government, because even our fundamental rights depend on us being healthy. So I think we have not to lose also this that public health. We're all interdependent of the population health. So yes, as Professor Klein said, governments cannot do anything they want. There are rules of the game, but we are now in a certain logic where the collective interest is kind of at the forefront. And yes, it can be justified that we have to promote this collective interest, and sometimes at the cost of some freedoms.
Okay, Professor Klein, you wanted? Yeah, please go ahead.
I just wanted to add one little thing. So the question of proportionality also is a very fact-specific one, and I think that it is important to recognize that the collective dimensions here. But I do think that there is a place, and an important place, for civil society to question some of these measures, and there are ways to do that. And so, for instance, the Canadian Civil Liberties Association today announced that it's instituting a charter case in Newfoundland for a woman who was denied entry to attend her mother's funeral. And her argument was that, she planned to self-quarantine for 14 days. The funeral home had agreed to provide 14 days for her to self-quarantine, and that stopping the travel altogether was not necessary, and certainly not proportional, since there were other less rights-infringing ways to achieve this. And I think those kinds of questions are important. It is important to do that. There was another example of a challenge of an Ontario regulation authorizing the disclosure of COVID-19 information to police. Well, that information could be subject to abuse. And so I do think that it's important to challenge these, but I think that there are ways to do that. And we have legal channels for this, and it's appropriate that there's going to be a wave of testing of the limits of government authority, but that for people to recognize that those responses may well be proportionate given the information that governments are working with at the time.
Mm-hmm. So in Mr. Torby's email, he did make a reference, and I want to come back to this. He talked about ensuring that this does not become a precedent moving forward. Should he or we be concerned at all that in the longer term, even after this pandemic is passed, that some of these restrictions that have been put in place and the governments have taken the liberty to put these laws in place might still be with us post-pandemic?
Yeah, I mean, I think that that's important. So, for instance, in France, post-Charlie Hebdo, there was a state of emergency that lasted for about 2 years. And this was followed by far more aggressive anti-terrorism legislation, far more rights interfering anti-terrorism legislation as a result of that. And I do think that there's a concern that we may become used to this. And that's why I think it's very important that our civil society continue to monitor limitations on rights to see whether in fact they are necessary, particularly as we hopefully move to a stage where COVID-19 doesn't require or may not require those kinds of restrictive responses.
Okay, thank you. So let me turn the next question over to you, Professor Couture-Menard. You referenced earlier the Public Health and Civil Protection Acts here in Quebec. So this question came in from Daniel Romero, asking specifically about those acts. It's actually a series of questions, so I'll go through them quickly. So he's asking, are these the only laws that presently empower our provincial and municipal governments to issue directives forcing businesses to close and issuing fines for congregating in private or in public? Are the directives themselves legal? Even if the act empowers our government to issue such directives, don't they still need to be legislated, and was this properly done? And finally, is there any kind of test or benchmark that has to be surpassed for something to qualify as a health emergency? There's a lot in there, but maybe you could sort of address what those acts allow governments to do and not do.
Mm-hmm. Yeah, of course, one might consider legitimately that I think the extent of the restrictions on individual rights and freedoms during this pandemic calls for more formal ways to order such coercive public health measures, for example, having them stated in a legislation. However, responding quickly is so crucial during a pandemic that public health legislation or emergency legislation tends to eliminate any sort of formalism for ordering measures. For example, the Public Health Act of Quebec indicates that the government or even the Minister of Health, if he or she has been authorized, may, without delay and without further formality, order any measure necessary to protect the health of the population. So actually in Quebec, only the declaration of the public health emergency is subject to formalities, not the measures themselves. And the declaration has to be published in the Gazette Officielle du Québec, although it becomes effective as soon as it is declared, not as soon as it is published. And in other provinces like British Columbia and Manitoba, the declaration of emergency is not even subject to any formalities. So I think two important considerations derive from this. First, because coercive measures can be adopted without democratic debate and without formality during a public health emergency, it is of high importance to understand and evaluate the benchmark that has to be surpassed for a situation to be considered an emergency and to know who decides that they are met. And this is definitely an element of our research project. And to continue with the Quebec example, the legislation states that a public health emergency can be declared when a serious threat to the health of the population, whether real or imminent, requires the immediate application of certain measures which are extraordinary. And then the benchmarks are similar in British Columbia and Manitoba, for example. And what is special is that since there's no precedent for this pandemic, there are no court decisions to provide guidance in interpreting these benchmarks. And the literature is very rare. So it'll be interesting to see if there were any debates or discussions around these benchmarks when they were adopted by provincial assemblies across Canada. And second, I think that the elimination of formalism and the level of discretion given to the authorities in ordering public health measures really call for transparency and solid mechanism for public accountability, like reporting obligations, at least after the crisis is over. And in comparing the provincial legislations, I noticed that in some provinces, public health legislation does not mention a mandatory reporting exercise post-crisis.
Mm-hmm. So I guess in many ways, we're actually living and creating legal history and legal precedents now that others will probably look back on years from now. And what did we do back in 2020 with the COVID pandemic? I do want to get to one more question. I know, Professor Khoury, I've got a few questions for you about government accountability and liability, but I have one more question about sort of the nature of these laws and how these compare to other laws that we have on the books that sort of protect ourselves and others. So a couple of examples I was thinking about as I was preparing for this afternoon was things like, mandatory seatbelt laws that some people, most people I think now generally accept as part of driving a car. More recently, we had the ban on smoking in bars and restaurants that I think probably took a bit longer for society to accept. But it seems to me like now everything's on warp speed. So COVID-19 hit us so quickly. There was very little time to react. One day we were living our normal lives, and the next day everybody was under sort of very draconian lockdown and stay-at-home orders. And I'm wondering, how does sort of societal acceptance play into this? When you compare it to other laws that have been put in place to protect ourselves and our own health, compared to what's happening here, and we're seeing, I guess, more resistance. Is it really just because of the speed at which everything has been moving that people haven't had time to gradually accept laws that they know are coming down the books?
I think I could probably answer that one, or I could give it a shot. So to me, this is about buy-in and public trust, which is exactly what I started with, right? That in order for a public health measure to work, there needs to be buy-in, there needs to be belief in the measure to a certain degree by the population. So before, and certainly I think we have that in relation to things like seatbelt laws. Before Corona came in, people were saying that liberal democracies will never accept the kind of draconian restrictions that we saw in places like China. And that may be true. China still has measures that are far more rights limiting than the ones that we currently have, including quite elaborate use of apps to allow people to go here and there depending on their health status. But in Canada, we also limit where people can go quite severely. And by and large, what's been interesting to me is to see that people were actually very quick to accept the conditions of lockdown in Canada. People were remarkably accepting of this, even at great personal cost. And that was because we were terrified. Lately, there's been, I think, more talk of losing patience, and this comes, I think, a little bit from fatigue, but I think it also comes a little bit from it's also fed by these kind of conflicting messages that we sometimes feel that we're getting from government. And sometimes there are important reasons for those changes, but for instance, I think in Quebec in particular, the kind of flip-flopping around schools has done a lot to undermine public trust. Lately, I think public trust, in the beginning, public trust was very high. Now that's less so. And so we've started to become more concerned about those. The other thing I just wanted to mention is that actually, we didn't necessarily adjust or accept all of these public health measures in the past as easily as maybe the question suggests. So for instance, drunk driving restrictions, it took actually quite a while for people to adjust to that. And in fact, there was sort of a norm of drunk driving for a long period of time. And in fact, there was quite a lot of constitutional litigation around restrictions on drunk driving, especially because legislators actually went very far. So for instance, there was in 1990, there was a constitutional challenge to what's called the random roving stop, which is the power of police to stop anyone for any reason to check for drunk driving, not just in a roadblock or not just where they have a basis to believe that there's impaired driving, but simply just to check. And that was considered by the Supreme Court to be a justifiable limitation on the right against arbitrary detention. But it issued a very strong dissent from one of the top Supreme Court judges, Justice Sapinka, where he called it the last straw of constitutional protections, the last straw against constitutional protections for people who drive.
Wow. So you mentioned sort of, you brought up the issue of Asia, and we're seeing some of the policies in China, and people are obviously willing to accept it. I guess there really is, when we talk about it, there is this sort of spectrum, societal and cultural norms, where maybe you've got the Asian countries and perhaps some Eastern European former communist bloc countries, perhaps, where there's more acceptance and trust in government. And then, of course, on the other extreme, we've seen some pretty shocking examples south of the border, our friends in the United States, where people are actively flaunting government, state regulations, and in fact, sometimes pitting governors against their own Supreme Courts in some cases. So how much does that sort of societal and cultural norm fit into a population's willingness to accept certain level of restriction?
I mean, it's such a complicated question, right? Masks were already the norm in Asia for people who were feeling sick before governments started to require them, before COVID even came to be something in our lives, right? So I do think that it matters. I think the situation in the US is much more complicated than sort of what we're culturally used to and what sorts of restrictions on our freedom we're used to. I think there's an extremely complicated political dynamic going on that has not been reflected to the same degree up here in Canada. So I do think that sort of culture makes a difference, but political context, I think, also makes a big difference. And I think the fact that we have robust rights protection in Canada and general trust in our courts and in our legal systems has actually been a very helpful thing. So I think civil society work like what the CCLA is doing is actually very important to maintaining that trust.
Mm-hmm. So Professor Khoury, I do want to spend a little bit of time looking at this notion of accountability. So we've already seen governments already in this pandemic called to account for what some have called poor decision making, whether it's allowing infections to spread so quickly in nursing facilities here in Quebec and elsewhere, or on the flip side, perhaps being overly cautious in forcing the cancellation of healthcare delivery for things like elective surgeries. Do you expect to see lawsuits filed against governments, nursing homes, or hospitals, or other institutions for some of the health consequences of the decisions that are being taken around the pandemic? And would these lawsuits have any chance of succeeding?
Okay, big question. Maybe before I just jump into the question, I think I'd like to recall something that you said at the beginning. You said, COVID-19 is an act of nature. We cannot sue COVID-19. And I think it's important to keep this in mind. And that may seem trivial, but I want to underline this because my sense is that the priority for law now is to facilitate or consolidate sound public health strategies rather than social antagonists, which is a little bit part of liability lawsuits. But this being said, in fighting the virus, obviously, as you allude to, it's possible that acts of negligence may be committed and which may cause injury that would not have otherwise occurred. These injuries, we can figure them out easily: sickness, death. But there's also a lot of economic and psychological injuries that are being suffered by the population. So maybe I'll focus on the government because I think it's important to understand the possibility of lawsuits against the government. I'll say a few words as briefly as I can about other actors. So theoretically, the different levels of governments can be sued for injuries caused by their actions, but governments are protected by a partial immunity when they take decisions that are based on public interest considerations. For example, decisions that involve economic, social, political factors are protected against liability lawsuit by an immunity that is only partial. And in my opinion, and I'll look more into this within our projects, I feel that most decisions that are taken by the provincial government right now, they fall into that category. And unless they're taking they are irrational or taking bad faith, I think the chance of successfully suing the state is very limited. And in fact, we do have decisions in Canadian law in health-related cases where the courts have refused to subject the states to liability rules when they allocate budget resources, when the state establishes priorities in the fight against some diseases, when the state designs health-related programs, when it assesses risks before deciding whether to regulate or not. And we even, I'll talk about some other cases that we've had concerning epidemics, not pandemics. What we might want to remember is that the idea behind this immunity is that we think as a society that the state should have the liberty to act in the manner it thinks best to reconcile all the different interests that are at stake without a judicial Damocles sword over its head. Of course, this is subject to the state respecting the rights and liberties protected by the charters that Professor Klein has mentioned before. And the immunity is also justified by the principle of division of powers, the idea that the state is accountable to Parliament and to citizens, but not to the judicial system. Outside of Quebec, there is a different legal tradition that applies, and therefore there is an additional hurdle that we have seen in a context that's very interesting for us to think of right now, which is the spread of SARS in Ontario in 2002-2003, and the spread in the same province of the West Nile virus. And what we've seen in class actions that have been taken, or individual cases that have been brought in the aftermath of those two crises in Ontario, is that courts there have shown really reluctance to impose on the province duties to particular persons or groups that could conflict with the duties the state has to the public at large when it manages a public health crisis. And notably, there were lawsuits taken against the province of Ontario and public health authorities for removing public health protections and releasing or canceling the state of emergency a little bit too fast, which allowed, after first wave of SARS contamination, for a second wave to occur. So I think we need to remember those cases, because that's a bit the fear that we're having right now with the confinement. Maybe quickly, there are limitations of liability that can benefit the state through legislation. The Federal Emergencies Act has a limitation of liability, but there are certain types of state decisions and action that are subject to liability lawsuits. And so our project will actually have to look at decisions on a case-by-case basis to verify if some of them may be subject to liability lawsuits. For example, there could be an argument to be made that public health authorities or public authorities' negligence in the practical implementation, not in the design, but in the implementation of a plan to fight infectious disease, could be subject to liability. So we'll have to look into this. So if I don't know if you want me to say a few words about lawsuits that could occur, not against the government, but other actors, perhaps.
Yeah, I mean, nursing facilities, I know, are one very particular example here in Quebec. But so what about sort of institutions that provide care, whether it be hospitals, nursing homes?
What we've seen in some cases in the past is that because the state has a protection against liability tends to trickle down to other actors. And in the healthcare sector, we've seen examples where liability trickles down to healthcare institution, healthcare staff. So that's a real possibility. And of course, we are seeing lawsuits against prisons. There might be lawsuits against schools, youth protection agencies, and we could go outside of the healthcare sector. There could be lawsuits against shops, manufacturers of defective protective equipment, airlines, etc. So that could happen. What we need to understand those with regards to those other lawsuits, so not against the state, is that most of these liability claims will require to prove negligence. For instance, negligence could be the omission to take reasonable precautions against the risk of infection. Because the pandemic situation is very new, there will be some challenge for the courts in identifying what the reasonable standards are in this respect. And I think they will need certainly to work with public health experts in this respect if they have to tackle those lawsuits. There's an additional difficulty in those lawsuits, which is that one has to prove, if we're able to prove negligence, we also have to prove that the negligence has caused the infection, which is difficult when we know that someone can be infected and asymptomatic during the incubation period, but also during the whole sickness, and that maybe not, the virus can spread in other manners to surfaces, although Alana was mentioning our knowledge is developing. So with the time that we have, and we're coming to the end, I cannot assess the chances of success because this is done really on a case-by-case basis, and it depends on the particular circumstances. But I think courts will have to take into account that we're in a very difficult emergency situation. We have limited resources. The scientific knowledge that exists at the relevant time is underpinning those decisions, and it evolves, so we cannot judge decisions or measures that are taken in the healthcare sector with hindsight. We have to get back to the knowledge we had at the relevant time. And of course, as I was mentioning at the beginning, and maybe I'll end with this, my answer, the causal path of infection is really difficult to identify, and because of the incubation period and the absence of symptoms. And so obviously that will complicate liability assessments. If I may say, there could be, I hope there will not be too many of those personally, there could be lawsuits from citizens against citizens. We have heard stories around the world about infected people knowingly taking a flight, attending an event, etc. If you know, you should know that you're infected, and if you know or should know about the risk of transmission and the need to stay isolated, obviously this has to be respected. There could be a liability attached to contravening rules about confinement and isolation. But again, it will be always very hard to identify whether we contracted COVID from, our neighbor who knocked on our door or through some other way. So here again, there would be difficulties with those lawsuits.
Right. Well, thank you for that. So as you said, we only have a few minutes left. I had no idea that law professors like to talk so much. So I do want to just maybe turn it over to Professor Couture-Menard. Just for one point, maybe you could talk briefly a little bit about the sort of intersection between the various governments and the sort of overlap of jurisdictions, federal, provincial, municipal. I think we saw a little bit of this take shape at Trudeau Airport very early in the pandemic, when I guess in the absence of the federal government's action, you had the provincial public health authorities and the city of Montreal sending, staff and police agents to the airport to greet passengers. How have you seen that all taking shape in sort of the midst of this crisis?
Yeah, well, yes, it's true that public health is a shared responsibility between the federal and the provincial territorial level, and also the municipal level, which they all intervene within their respective areas of jurisdiction. So in our project, I wish to examine more closely this dynamic, not necessarily in the sense of, should we see this event that took place at the airport as So I just want to recall that the provincial public health authorities and the city of Montreal acted together, so two different levels, to compensate for a federal intervention at the borders that they considered insufficient. So should we see this event as a confrontation illustrating the perverse effects of interventions from multiple levels of government during a pandemic? Or could we see it as a proactive and creative way to use respective legal powers to offer a more complete response to the crisis? I think it's important to foster collaboration between levels and not always presume that the plurality of levels mean conflict. It can rather mean opportunities for the levels to be complementary. So this will be another aspect of the research.
Great. Well, thank you for that insight, and we look forward to seeing how the research plays out. So again, we only have a few minutes left, so maybe I'll just go around one last time. I'll just ask each of you if you could maybe give me a brief 60-second, 90-second answer to the final question to each of you, which is, now that we're sort of in the midst of all of this, I know we're dealing with a lot of evolving situations, but what would be your predictions, or where do you see the longer term legal implications of this pandemic going? Are there any particular lessons that you are looking to, you're looking for any observations that you want to sort of take out of this that you think will serve future governments and policy and decision makers well when they look back, years from now? Maybe I'll start with you, Professor Klein. You're still on mute.
Yes, I got it.
There you go.
Yeah. So for me, what I was going to say is that this pandemic, I think, has brought us tremendous opportunities for unifying people in the name of public health. Public health does not often, we all found ourselves a little bit surprised by this pandemic in a unique way related to our work, because public health does not always attract the kind of broad interest that we've seen over the last little while. And so I look at this as kind of an opportunity for, again, to unify people in the name of public health and to help them to recognize that we are interdependent with one another, and that our health is not some individual atomized phenomenon that exists only within our bodies, but that we share with one another. And for the government to earn our trust by being transparent, by communicating with us clearly, by acting based on the best available information at the time, with due consideration of rights, and by communicating that to us. So in short, my hope would be that this pandemic will bring opportunities for Canadians to recognize that public health requires us each to look out for each other.
Great, thank you. And Professor Khoury now?
Yes, for my part, there are so many things to, so many possible answers with this unique experience. But I would add that this pandemic has revealed for me how urban planning is relevant to the prevention of or the response to a pandemic regarding public transit or active commuting, use of public spaces such as parks to meet with people, and access to affordable and appropriate housing. So I think and I hope the pandemic will foster a reflection on how cities can use their legal powers to offer an environment that enables people to live in accordance with public health instructions or measures or recommendations.
Great. And Professor Khoury, we began with you. Maybe it'll be fitting to end with you.
Thank you. Well, many things, but I think we will understand better the complexity of public health decision making and all the ramifications that it has in all spheres of our society. And I liked what Professor Klein said. I think also we will understand better the complex web of interdependent responsibilities that we all have, and that all the responsibilities of the different actors of society are interrelated and must be complied with in collaboration. I also hope that it's going to give us the occasion of developing a stronger accountability mechanism for public decision makers and Professor Couture-Ménard has alluded to, transparency, open communication from the state, open discussion of state measures, responding also to victims' needs. So I hope we will develop stronger accountability mechanisms that will maybe serve us, hopefully not in another crisis like this one, but perhaps in other contexts.
Great. Well, thank you. Thank you so much. So that does just about wrap up the time we do have for today, but what a fascinating conversation. I really appreciate you taking the time to join us for this today. Before we close, I would like to remind everyone that this video will be available at this very same link soon after our recording ends. So feel free to share it with others who may not have been able to tune in live. Please keep watching your email and social media feeds for more information about how McGill is confronting the challenges of COVID-19 and keeping you informed with insight from our academic, medical, and legal experts. If you are a McGill graduate who is not currently receiving our emails but would like to be added to our distribution list, you can visit alumni.mcgill.ca/register to sign up. That link will be available beneath the video player on our YouTube channel as well. And of course, again, a very big, sincere thank you to our three guests today, Professors Lara Khoury, Alana Klein, and Marie-Ève Couture-Ménard, for joining us and delivering such interesting insight into an angle of the COVID-19 pandemic that is sure to take on an even more prominent role in the coming weeks and months. Please be sure to join us again next Thursday when we explore one of my favorite subjects, food. Is it safe to bring groceries and takeout food into our homes? Do we need to get accustomed to shortages of products such as beef, poultry, and vegetables as the pandemic knocks food processors and farms offline? And we'll have two professors from McGill's McDonald campus who will be with us to answer all of your questions about food safety, food supply chains, and the shortage of hamburgers during the COVID-19 pandemic. So until then, please stay safe and be well. And I hope to see everyone back here again next week. Thank you.